Dear students, today we take up for discussion the anthropological approach of Sir Henry Maine. Anthropological investigations into the nature of primitive and undeveloped systems of law might be regarded as a product of the historical school. Pride of place will here be accorded to Sir Henry Maine, who was the first and still remains the greatest representative of historical movement in England. Some of the important works of Maine are Early Law and Custom, Early History of Institutions, Village Communities in the East and West, Ancient Law, its connection with the early history of society and its relation to modern ideas. It would be worthwhile to know about the background of Sir Henry Maine. He was educated at Cambridge and appointed as Professor of Civil Law at Cambridge. His lectures at Inns of Court formed the basis for ancient law, which is his major contribution, for which he is most generally known today. As a successor of Macaulay, Maine served from 1863 to 1869 as legal member of the Central Legislative Council in India. While in India, he studied the law and legal institutions of India, comparing them with modern societies of the West. He became an authority on Indian law besides his background of Celtic, Roman, Anglo-Saxon, Hebrew and Germanic legal systems. Sir Henry Maine was the founder of English Historical School of Jurisprudence. He agreed with Savigny's view, but he went beyond Savigny in understanding law by comparative studies of legal institutions in primitive as well as progressive societies. In fact, Maine departed from Savigny in two important respects. He believed in stages of legal evolution in the course of which primitive ideas may be discarded. He sought to discover by comparative studies of different legal systems the ideas which they had in common. He was an authority in Roman law, English common law and Hindu law. His most important work, Ancient Law, was published in 1861. It is considered to be a seminal work not only in the field of law, but also within anthropology and sociology. Ancient Law collects, discusses and explores the development of significant legal ideas and practices from a broad range of human societies. Development and the growth of law. Henry Maine observed that there had been a parallel and alike growth and development of legal institutions and law in the societies of the East and West up to a certain age. On the basis of the comparative studies, he distinguished between static and progressive societies. He observed that societies in the East were static, whereas society in the West were progressive. The early development of both in static and progressive societies was roughly the same. The early development, according to Maine, falls into three stages. Henry Maine interpreted history as providing proof of the existence of stages in the evolution of law. Three distinct stages in legal development may be discerned in the history of the past. In the first stage, law emerged from judgments of rulers. For example, era of Themistus. In the second stage, those judgments transformed into customs, that is, era of customs. In the third stage, the art of writing produced codes of law, that is, era of codes. The first stage, that of lawmaking by personal command, believed to be of divine inspiration, for example, Themistus of ancient Greece, and the dooms of the Anglo-Saxon kings. Themistus are the first earliest forms and instruments of law, having originated from the Homeric words Themis, which means the goddess of justice. Themistus therefore are awards and judgments pronounced by goddess of justice to be executed by the king as a custodian under divine inspiration. Themistos are not laws, but judgments delivered and administered by the royal kings with divine inspiration. Era of customs. The second stage occurs when those commands crystallize into customs. Due to the recurring application of judgments led to uniform practices and habits, resulting in the growth of customs in the primitive communities. This was the period when the office of the king or judge was usurped by a close oligarchy of priestly class learned in law and religion who claimed to be sole repository of customary law. The priestly class preserved the entire customary rules through memory because the art of writing had not been invented during the said period. Thus, in the second stage, the ruler is superseded by a minority who obtain control over the law, for example, the pontiffs of ancient Rome. Era of codes. The second stage is followed by era of codes. The third stage is the revolt of the majority against the oligarchic monopoly and the publication of the law in the form of a code. For example, Hebrew Code, Hindu Code of Manu, 12 tables in Rome, etc. These codes emerged following the discovery of the art of writing. A class of lawyers, jurists, and learned scholars in law appeared who broke the monopoly of the priestly class by codifying the law to make it accessible and easily knowable. Such codes provided a definite, clear, and positive basis of law against frauds and manipulations of the priestly class. Static and progressive societies. Henry Maine observed that societies are either static or progressive. When the primitive law has once been embodied in a code, there is an end to its spontaneous growth. Static societies do not progress beyond this point. Law is stable and society is also static. In progressive societies, a general proposition of some value may be advanced with respect to the agencies by which law is brought into harmony with society. If any changes are required in law, they are effected deliberately by some formal authorities. A new era begins after codes. Machinery of change. According to Maine, in progressive societies, law proceeds to develop through three new instrumentalities: legal fiction, equity, and legislation. The characteristic feature of progressive society is that they proceed to develop the law by these three methods. These three instrumentalities constitute a machinery of change. Change may be effected judicially or through legislation. Judicial methods include use of fictions and equity. Legal fictions. According to Maine, the first great instrumentality of legal reform was fiction. He defined fiction as any assumption which conceals or affects to conceal the fact that a rule of law has undergone alteration, its letter remaining unchanged, its operation being modified. Fictions need to be distinguished from shifts in the meaning of words. For example, the word possession was originally applied to physical control. Then it came to be applied to situations where there was no physical control. There was no pretense about the facts of either situation. Adoption, on the other hand, is not a shift in the meaning, but name for a pretended fact, namely that the adopted child was born into the family. A more difficult case is that of the corporate person. One application of the word person is to a human being. Its application to a corporation is best treated as a shift in meaning. Professor Julius Stone observes, fictions are swaddling cloths of legal change. Legal fictions proved useful agency of development as they satisfy the desire for improvement, but at the same time they did not offend the superstition, fear, and dislike of change. Fictions are invaluable expedients of social change and progress for overcoming the rigidity of law. For example, the Roman fiction that a foreigner was a citizen for the purpose of litigation at hand, or the fictions which permitted adaptation of the ancient Roman legal procedure to the needs of foreign commerce and commerce generally. Similarly, the English legal fiction that the king is dead, long live the king has still great historical and legal importance. Professor Fuller declared the following motivations behind the use of fictions. Number 1, policy. The point that most fictions in fact deceive no one weakens the charge of concealment. There are reasons of policy behind fictions. For example, the rule that husband and wife are one, even the old rule that a wife was deemed to have committed a crime under her husband's compulsion was not introduced originally to deceive anyone. Number 2, emotional conservatism. Fuller said this is the judge's way of satisfying his own carving for certainty and stability. Number 3, convenience. This consists of making use of existing legal institutions. Number 4, intellectual conservatism. Fuller said a judge may adopt a fiction not simply to avoid discommoding current notions or for the purpose of concealing from himself or others the fact that he is legislating. Equity. Equity belongs to a more advanced stage than fictions. Equity in English and Roman legal system came to remove the rigidity of law and to remove injustice, delay, and other inconveniences. In one sense, equity is synonymous with justice. Maine defined equity as any body of rules existing by the side of original civil law, founded on distinct principles and claiming incidentally to supersede the civil law in virtue of a superior sanctity inherent in those principles. One function of equity is to mitigate in various ways the effects of the strict law in its application to individual cases. Another function is to procure a humane and liberal interpretation of law. In English law, the question of conflict between common law and equity has been the subject of some controversy. The Judicature Act of 1873 provided, generally in all matters not herein before particularly mentioned, in which there is any conflict or variance between the rules of equity and the rules of the common law with reference to the same matter, the rules of equity shall prevail. It is clear, therefore, that equity arises out of the process of law applying. In Roman law, the rigidity and shortcomings of the civil law were remedied by the judges with the help of principles of equity. Equity follows the law not to supplant it, but to supplement it. If we trace out the origin of equity, it may be traced back to late 13th century, when traditional common law was in operation in England from the time immemorial. In England, the common law judges, by adopting a logically rigid interpretation of law, forced the ordinary people to look for justice to the king, who was the fountain of justice. The king in turn authorized his chancellor to provide alternative equitable remedy where the common law judges failed due to formality and technicality of law. The common law at that time suffered from three defects, namely absence of remedy in certain cases, inadequacy of remedy, and excessive formalism. These defects were sought to be removed by three jurisdictions of equity, namely exclusive jurisdiction, concurrent jurisdiction, and auxiliary jurisdiction of equity. The origin of concept of trust, appointment of receiver to administer the property of the deceased, fell under exclusive jurisdiction of equity. Such remedies were not available under the common law. The remedies of specific performance of the contract, injunction, etc., came under the concurrent jurisdiction of equity, which provided relief in matters where a relief, though available under common law, was inadequate. The examination of witnesses on commission, set off, etc., are some of the instances of auxiliary jurisdiction of equity, which sought to mitigate the rigors and rigidity of common law due to complexity of procedure. Legislation. Legislation is the last effective instrumentality of quick social reform. It is perhaps the only method for dealing with new complex problems in a modern state. The courts and the people accepted the vast powers of modern legislatures to effect changes and reforms through legislation in a planned and deliberate fashion. As a general inference, Maine believed that no human institution was permanent and that change was not necessarily for the better. Unlike Savigny, Maine favored legislation and codification. With the rapid changes now taking place, this is the only efficient way of dealing with the problem. He recognized that the advance of civilization demanded an increasing use of legislation, and he often contended that the confused state of English law was due to its preeminently judge-made character. Codification is advanced form of legislative development. Law reforms and codification are the two legitimate functions of the legislatures. Codification. This is a phenomenon which is found at various stages of development. Undeveloped systems often start with codes. Maine opened his classic work with the remark, "The most celebrated system of jurisprudence known to the world begins as it ends with a code." Codification is said to provide a fresh start, but this must not be misunderstood. Fresh start cannot mean an entirely new kind of law. Therefore, codification must be of the existing law, and the question is what shape and form it should assume. Movement from status to contract. Side by side with above doctrines, Maine developed another thesis. In early societies, both static and progressive, the legal condition of the individual is determined by status. That is, his claims, duties, liberties, etc. are determined by law. The march of progressive societies witnesses the disintegration of status and determination of the legal condition of the individual by free negotiation on his part. This was expressed by Maine in the following dictum: "The movement of progressive societies has hitherto been a movement from status to contract." According to Maine, the unit of ancient society was family, but individual is unit of the present society. The authority of the pater familia, that is patriarch of family, and dependency of the family become obsolete and dysfunctional, yielding place to the growth of individual rights, individual personality, and individual freedom and obligations. This led to disintegration of the family system, end of the dependency on the pater familia, and emergence of contractual relations among individuals. Now, the individual become the best judge of his own good. Law accordingly recognized the individual as the sole subject matter of rights and duties in place of pater familia, who was previously the sole repository of power. In England, the movement from status to contract began with the repeal of old laws which put fetters or restrictions on individual freedom by denying them rights. The new laws conferred contractual capacity on the individuals, enforcing rights for or against the individuals. In Roman law, there was the gradual amelioration of the condition of children, women, and slaves, the freeing of adult women from tutelage, and the acquisition of a limited contractual capacity by children and slaves. In English law, the bonds of serfdom were relaxed and eventually abolished. Employment came to be based on a contractual basis between master and servant. With the growth of commercial and industrial culture, law of contract acquired added significance during 18th and 19th centuries. Hence, the theory of free contract came to extensive use in trading and commercial world. The introduction of free education, open system of voting, abolition of slavery, extending of representation to middle and lower classes, removal of disabilities on the basis of status, separation of married woman's personality from that of the husband, Benthamite doctrine of free contract for regulating relationship between individuals, social contract theories founded on the notion of free contract or agreement between people and the rulers, free will theory of Kant, the doctrine of liberty, equality, and fraternity of the French Revolution, doctrine of inalienable natural rights of man of the American Declaration of Independence, philosophy of laissez-faire in economic, political, and legal theories, relationship between master and servant, employer and workman, wife and husband, parents and children, annulment of the common law doctrine of common employment, etc., are the examples to support the dictum movement from status to contract. All these factors led Sir Henry Maine to observe that the movement of progressive societies has hitherto been a movement from status to contract. This thesis is an outstanding contribution to legal theory. Movement from contract to status. It must, however, be stated that with the advance of time and due to the impact of industrialization, urbanization, and modernization, new problems of unemployment, hunger, ignorance, disease, etc. have cropped up, giving rise to inequality between individuals and groups within the society. Consequently, there came a counter current of reversal from contract to status. The emergence of trade unionism for collective bargaining, enactment of several labor welfare legislations to improve the service conditions of workers, the increasing role of the state in a welfare state, the interference of the state in the individual activities, the constitutional commitment to promote economic interests of weaker sections of society, nationalization of services and industries are some of the instances to illustrate the reversal trend of movement from contract to status. Critics of Maine suggest that the 20th century developments may be interpreted as indicating a move from contract to status in some areas. For example, as in the case of industry-wide collective bargaining, standardization of contract terms, and protective social legislation. It must, however, be pointed out that perhaps Sir Henry Maine was conscious of the fact that the movement of progressive societies from status to contract may undergo a change with the passage of time. That is why Maine qualified his statement by using the word hitherto, signifying that until then the movement of progressive societies was from status to contract, thus leaving options open for a change in future time to come. Maine's thesis criticized. It should be remembered in connection with the following criticisms that Maine was writing at a time when anthropology was in its formative stage. Relatively, little was understood of the techniques of field study. There were large gaps in the known history of early ages. Maine extrapolated well beyond the data available to him. Diamond, in his Primitive Law, pointed out that the very title of Maine's study, Ancient Law, indicated a failure to understand that the study of the origins of law demands evidence as to the beginnings of law, both as we know of them in the past and as we see them in the present. After looking into the history of legal development of various communities, one can easily say that the trend has not been uniform everywhere. Early society does not show an invariable pattern of movement from charismatic judgment through aristocratic interpretation to code. The rigidity of primitive law, as portrayed by Maine, is challenged repeatedly by contemporary anthropologists. Maine's classification of societies into static and progressive appears to have been superseded by the work of anthropologists. Custom is not distinct from law in all early societies, as Maine implied. The patriarchal system was not universal. Matriarchal systems were often widespread. Progressive societies also move from contract to status. So, Maine's generalization does not hold good in the 20th century. Effect of Maine's thesis. Historical jurisprudence would always remain indebted to Sir Henry Maine for his substantial contribution to the juristic thought. Sir Henry Maine is considered to be the founder of comparative jurisprudence. By studying law as it was placed within the structures of society, Maine has provided in ancient law some of the most valuable parts of the theoretical framework for analyzing legal institutions. The most conspicuous feature of Maine's work is the breadth and brilliance of his generalizations made on the basis of a comparative study of legal institutions in various societies at different levels of historic development. None of his theories has passed without challenge. The researches of scholars of comparative jurisprudence have revealed that his doctrines require modification and qualification in various directions. However, none can impugn the originality of his methodology. Maine taught that this historical perspective informs a lawyer that the law possesses a history of its own beyond that of politics and constitutions. Jurists like Maitland, Vinogradov, Pollock and Bryce were inspired by Maine, and they applied his historical and comparative method to the study of law. This lesson is an attempt to explain contribution of Sir Henry Maine to legal thought in general and to historical jurisprudence in particular. Thank you.